Hi, everyone. Thanks for joining our webinar today. I will begin the program now by going over the agenda. So in a few moments, I'll turn the program over to one of my colleagues in our Rochester office, Nick Jacobson. Nick is going to update us on a new law that took effect recently that impacts the New York weekly pay provision for manual workers. Next, we will have Gavin Gretzky from our Syracuse office. Gavin will update us on legislation that's currently pending that would change the nature of severance or separation agreements in New York State. And last but certainly not least, we have Barbara Lee with us. Barbara will be discussing a Department of Education communication requiring institutions to contact students about loan debt. Okay, I will now turn the program over to Nick for his update. Nick?
All right, thanks, Carrie. So many of you probably have seen me on here talking about this topic before, manual worker weekly pay requirement. And this time I actually finally have some good news. Next slide, please. So for just a quick reminder, in New York, Labor Law Section 191 generally requires that manual workers be paid on a weekly basis, not later than 7 days after the end of the week in which the wages are earned. Manual workers are defined under the law very broadly as anyone spending more than 25% of their day performing physical labor. And as you can see, that's been interpreted to include a wide variety of workers, from carpentry workers to cooks and wait staff, airport chauffeurs, taxi drivers in some cases, pizzeria workers, all have been found to be manual workers. So it really covers quite a broad spectrum of employees. Next slide, please. So there were two cases with different determinations from New York's appellate courts with respect to what a violation of this law means. So the first department had a decision issued in 2019 in Vega, in which it determined that manual workers have a private right of action to recover wages paid on a late basis under New York Labor Law 198. They held that the moment an employer fails to pay wages on a weekly basis, it paid the employee less than what is required, and that allows the employee to recover liquidated damages. The second department, disagreed in Grant and found that there's no private right of action under Section 191. While Section 198 allows for the recovery of non-payment of wages, untimely payment, according to the second department, isn't the same thing. Next slide, please. All right, so under Vega, which was actually adopted by most of the federal courts looking at this issue as well, exposed employers to liquidated damages up to 100% of the total wages due. So in that case, for manual workers that were paid late every other week, if they were paid bi-weekly, those employees could, in theory, recover up to 3 years of lost wages, despite having actually been paid in full. So obviously you can see why this is a huge concern for employers. Next slide, please. So as I mentioned, I've been on a number of times over the last couple of years talking about this issue. Governor Hochul and many members of the legislature recognized, what a potential problem Vega presented and how far-reaching those consequences could be. Last year, Governor Hochul included proposed legislation in the 2025 fiscal year budget, but the legislation actually wasn't adopted as part of the budget. So we thought we were going to be at this point last year. In between then and now, there were several other bills that were proposed, but none of them gained any traction in the legislature. This year, Governor Hochul again proposed legislation in her 2026 fiscal year budget, but she really kept us, and the legislature kept us on our toes and made us nervous waiting this out. But finally, after the budget was extended a couple times, next slide, please. Finally, we've got our Education, Labor, and Family Assistance Budget Bill, which was adopted on May 7th of this year, and it includes a modified version of the legislative fix that Governor Hochul had proposed. Next slide, please. So the ELFA fix, the new legislation amends Section 198 of the labor law to establish that liquidated damages are not available where the employer paid the employee wages on a regular payday, no less frequently than semi-monthly. Damages for late payments in violation of 191 are calculated at the daily interest rate for each day payment is late based on the annual rate of interest then in effect. For violations occurring prior to the effective date of this law, employers without previous violations can be liable for up to 100% of lost interest. Employers that did have prior violations can be held liable for up to 300% of the lost interest. Next slide, please. Going forward, for violations after the effective date of the amendment, which was May 9th, employers can be subject to liquidated damages where they've previously been found to have violated the statute with respect to workers performing the same type of work. So say you've got a claim previously, say you're a restaurant and you didn't pay your wait staff on a weekly basis and you were found liable. If you're found liable again, you could theoretically owe those employees liquidated damages because the amendment has occurred and you've been found to have violated that law with respect to the same type of worker before. Otherwise, you're going to be looking, if you don't have that prior violation, you're going to be looking at exposure limited to just the lost interest for the late payments. The interest rate is set by the Department of Financial Services under Section 14A of the banking law. Currently, it's at 16% annually. And this statute, very importantly, applies retroactively to any causes of action pending or commenced on or after such date of the effective date of this law. So for any cases pending, this legislative fix would apply. For any cases filed in the future, this legislative fix would apply. Next slide, please. All right, so the takeaways, thankfully, this significantly reduces exposure for employers. I'll preface this with the fact that I'm not a fantastic math person, but I sat down with a colleague of mine who is very good in that regard today, and we did some quick back of the napkin kind of calculations. Looking at it, I think for an employee, for example, who made, say, $100,000 a year and was paid on a biweekly basis, the exposure from the employer looks like it could go from $300,000 to just a few $1,000s. So it's a huge difference for employers. The retroactivity of the law is likely to be challenged by plaintiffs' attorneys. There's a lot of cases pending. There's a lot of very motivated plaintiffs' attorneys that would like to see that retroactive provision overturned, given the difference in recovery that they could expect. So we'll have to monitor any challenges to that. Also, to keep in mind, employers still need to correct the practices if you're not currently complying. Even if your exposure is limited to the lost interest, you still don't want to go through the process of a lawsuit and fight discovery and all that. So definitely, if you're not complying and paying manual workers on a weekly basis, you want to make that change now. If you have questions as to whether particular workers are likely to fall within the scope of a manual worker, also, please don't hesitate to reach out to us. We're happy to help walk you through any of those issues. And I think that's it for my portion, Carrie.
Great. Thanks a lot, Nick. We appreciate the update. Hopefully there is now more awareness of this weekly pay provision, but glad that there's some relief for employers who aren't aware of it. Okay, next up we have Gavin to discuss the severance agreement legislation. Gavin, thanks for joining us today. I'll turn the program over to you.
Great. Thank you very much, Carrie. Yeah, so today I'm going to be kind of giving an update on some legislation that is making its way through the New York legislature, the No Severance Ultimatums Act, SB 372 recently passed the Senate in March. As it currently stands, it has been introduced into the New York Assembly following the Senate vote as Assembly Bill 6480, and it's currently referred to committee in the Assembly. A little history on this act. It has been introduced twice previously in 2023 and 2024, but both times it failed to make it past the Senate in each of those legislative sessions. But we wanted to bring this to your attention today because there has been a lot of discussion and articles written on the topic recently, and wanted to bring this up and make the and let you know that even though this has passed the Senate yet, it is not law yet. It still has to make its way through the entire legislative process and be signed, but because of the chatter around it, wanted to make you aware of it and give a brief overview of what the act would entail, because if it does pass, it could have some significant impacts on separation and severance agreements. So a quick overview of the No Severance Ultimatums Act. It would add a new section to the New York labor law as section 215D. It would apply to all employers and employees as defined in the New York labor law, which means it would apply to any employer, no matter how many employees you have. And unlike the Older Workers Benefit Protection Act, which has age limits, which we will discuss a bit later, this would apply to all employees no matter their age. So it doesn't matter if they are 40, 60, or 20. It would apply to any employee under the New York labor law, as well as extending applicability to employees of governmental agencies. Notably, however, the No Severance Ultimatums Act does not apply to severance agreements that are negotiated through any collective bargaining agreements. So there's a notable exception in the bill as it stands right now. The requirements of the No Severance Ultimatums Act states that employers must inform employees in writing when presented with a severance or separation agreement of their right to consult an attorney. They must provide the employee at least 21 business days to consider a severance agreement before signing. And this must all be in writing. And take note, this is 21 business days, not calendar days. So because it's business days, it could extend the period that employees have to consider these agreements for lengthy periods of time, depending on the presence of any holidays that may coincide with when they are presented with these agreements. And the agreement must also state that the employee may revoke a signed severance agreement within 7 days of its execution, and that any agreements are not effective until that 7-day period has run. Now, under the bill, any failure to meet these requirements would render any severance agreement void and unenforceable, which could impact the validity of these agreements and any severance payments that are sent out to employees. Now, as the bill currently stands, there are some issues that potentially in the language. For example, in the bill currently, it states that an employee may sign the agreement prior to the revocation period, as long as the employee's decision to shorten the revocation period is knowing, voluntary, and not induced by the employer through fraud, misrepresentation, or a threat to withdraw or alter the revocation period before the end of the revocation period, or providing different terms to employees that sign the agreement before the end of the revocation period. Now, what makes this language confusing is that it references the revocation period in the bill, but what it appears to mean is really the consideration period, that 21-day consideration period, because the 7 days would be the revocation period. And if it does refer to this 7-day period, then this would put the act in conflict with federal law that also creates a 7-day period, but that cannot be waived or shortened by the employee. And so since this is currently with the Assembly, we will have to see what the Assembly does with this language and see if they take any steps to clarify it or make any alterations to it. And also, as the bill is currently written, It would take immediate effect if it is signed into law. But again, as a reminder, this is not yet law. It is still just with the assembly. So if the bill does pass, it will place additional requirements on all employers, and it will extend the time that any severance payments are paid out to all separated employees up to 21 business days plus the 7-day revocation period. And so because of this impact, the potential impact this has on separation agreements for all employees under New York law, if it does pass, we also wanted to take this time to give a comparison and overview / refresher of the federal statutes that exist on this matter, most notably the Older Workers Benefit Protection Act and the Age Discrimination in Employment Act. And so the New York bill closely resembles certain requirements of the Older Workers Benefit Protection Act. It establishes certain, now under the federal statute, it establishes certain requirements if an employee is to waive ADEA claims in a separation agreement. And so some of these requirements include that it applies to all employees that are 40 years and older. Now that's the notable distinction I made earlier, where federal law applies to older workers 40 and up, whereas the state bill would apply to any worker regardless of age. And if an employee is terminated, they must inform them in writing in plain language, which that plain language requirement does not exist in the New York bill. And under the federal statutes, the release must specifically reference the ADEA. The release must state that the waiver does not apply to claims that may arise after the waiver is signed. The release should specify what consideration was offered for the waiver, and there must be consideration offered beyond what the employer may already owe to the employee by law or contract. The writing must advise the employee to consult with an attorney before signing the agreement, which is mirrored in the New York bill. And the federal law must provide either 21-day notice or 45-day notice. The 21-day notice is applicable if it is an individual separation agreement, whereas the 45-day notice is applicable for any group layoff or reduction in force, or if there is an exit incentive plan. So it applies to, even if 2 employees are let go together, the 45-day notice will kick in instead of the 21-day notice. Now, again, comparing to the New York bill as it stands, the New York only requires 21 business days for all circumstances where there is a severance agreement. So there will be some overlap potentially between what may be acceptable under the federal side or the state side, depending on what the bill ends up coming out as if it does go into law. And like I said earlier, another requirement on the federal side is the employer must provide a 7-day revocation period after the employee signs. This is a right that cannot be shortened or waived by the employee. And because of the current status of the New York bill and its language, there may be some conflict between these two. Now, in the event of group layoffs under the federal regulations and statutes, the employer must also provide documentation in the agreement on any decisional units that are the subject of the group layoff and the eligibility factors considered for the program, as well as the job titles and ages of all individuals selected and not selected for termination. So it's kind of a brief overview and refresher on the federal requirements, as well as how they compare to what is in the current bill. Now, going forward, some recommendations for employers are that this would, because of the current status of the bill and the chance that it might be passed this legislative session, this is always a good time for employers to review your existing separation and severance agreements to make sure that they currently comply with the federal statutes, just to make sure that you are in compliance with those as they are currently in effect. And if the bill does pass, to update the language of separation agreements to ensure the compliance to ensure compliance with the requirements of the No Severance Ultimatums Act if it does pass. And in the event of that occurring, this is something that our firm can help with if the time comes. And so if that is something you'd like us to look into, if that happens, we're always happy to do so. And of course, we will be monitoring this bill for any updates as it makes its way through the legislature. So, and that is my update on this, Carrie.
Thanks, Gavin. We appreciate the update. As Gavin mentioned, we're always happy to help prepare separation agreements. So feel free to reach out. It's also important to keep in mind that if you're preparing a separation agreement for an employee working remotely in a state other than New York, you'll want to ensure that your release covers claims in that state as well as New York State, and that the agreement doesn't run afoul of any laws in the state where the employee is working. So, just keep that in mind as you prepare these agreements. Gavin, do you know whether the No Severance Ultimatums Act would apply to an employer located outside of New York if the employer has an employee working remotely in New York?
Right. So kind of how you just phrased it, the way it's looking right now is that the bill will most likely provide protections to all employees within New York, regardless of the location of their employer. So if you're out of state but have employees working in state, it is likely that this will provide protections, and any severance agreements or separation agreements for these employees in New York would have to be compliant with the New York law if it were to pass.
Okay, yeah, that makes sense. Thanks. We appreciate the update, Gavin. I will now turn things over to Barbara Lee, who will discuss the recent Department of Education communication. Barbara?
Thanks so much, Carrie. Good morning, everyone, or I guess it's afternoon for most of us. I'm going to be talking specifically about a federal requirement that affects colleges and universities, but it occurred to me as I was thinking about what I was going to say today that even if you don't work at a college or university, if you have a student loan, a federal student loan, or someone in your family or your friends have a federal student loan, I think this information would be very helpful and important to you too. Next slide, please. So the Department of Education has been quite busy communicating with those of us who represent colleges and universities and those institutions themselves this spring. And the most recent communication from the department is that all colleges and universities that participate in the federal student loan program, which is almost every college and university in the country, and certainly in New York State, have to reach out to their students who are loan recipients by June 30th of this year, which is right around the corner. The department said in its communication that, as you can see, 38% of direct loan and education department held federal family education loan program borrowers are in repayment and current on their student loans. That's only a little more than a third. And they estimate that about 25% of the entire loan portfolio, federal student loan portfolio, was either in default or in a late stage of delinquency, which means it'll be in default quite soon. Now, you may recall that in 2020, during the COVID crisis, that the department paused on loan collections, but they resumed collecting loan debt in October of 2023, which is a while ago. And so pretty much anybody who has not resumed repaying their federal student loans is going to be in default. So the department is requiring institutions to contact students with student loan debt, and the next slide will tell you which one of those you need to talk to by June 30th. So the requirement is all student borrowers who have not been enrolled at your institution since January 20th, 2020 must be contacted by the end of June. And these three bullets are in the Secretary of Education's letter and must be in this communication with those former students since they're not enrolled at your institution right now. They have to be reminded of their obligation to repay any federal student loans that are not in deferment or forbearance, and deferment or forbearance are pauses in the requirement to repay the student loan, but they don't last very long. So most of your students probably are not in deferment or forbearance. You must suggest that the borrower review information on the website for the financial aid program about options for repayment, and there are several of them. And then you're also required to ask the borrower to log into that website using their username and password to update their profile with current and contact information, because of course some contact information may have changed since they originally took out their student loan. Next slide, please. So the Education Department was very clear. There will not be any mass loan forgiveness. Now, you may recall that under the Biden administration, there were several attempts to forgive federal student loan debt. They all got knocked down by the courts, and the Trump administration has made it clear that they will not be asking for or realizing any mass student loan forgiveness at all during his administration. And they also have said that they're going to start sending notices about wage garnishment for those borrowers who are in default. So they are taking this very seriously, and it's very important for your former students to understand this so that they can get this taken care of before they start to get either their wages or perhaps their tax refund garnished. Next slide, please. So another twist of the knife coming from the Education Department is that the whole issue of cohort default rate. And that's a very technical term, which means that the institution itself could lose eligibility for federal student aid assistance and not be able to get Pell Grants or federal student loans if their cohort default rate exceeds 40% for a single year or 30% for 3 consecutive years. And that's a very serious situation for an institution of higher education to be in. And if you want to know what the term cohort default rate means and how it's calculated, there's a 15-page document on the Education Department's website that will give you all of the details about how the cohort default rate is calculated. My guess is that for those of you in higher education institutions, your student financial aid office is quite aware of the institution's cohort default rate, but it's a good idea to find out what it is and see if you need to start worrying about it or if you're going to continue to worry about it. And the department has said that it's going to calculate non-repayment rates for every college and university. In fact, it already has over the years that participates in the federal student aid program. And it will publish this information later in May on the Federal Student Aid Data Center website. Next slide, please. So that's the situation that we're dealing with. We will be happy to help you. Federal student aid regulations and laws are complicated and murky, and we have a number of folks at Bond in the higher education practice who would be delighted to help you make your way through this situation. Back to you, Carrie.
Thank you, Barbara. We appreciate the update. And thank you everyone for tuning into the webinar today. We have the contact information for all of today's presenters on the screen now. Please feel free to contact any of us or myself, with any questions, any of the presenters or myself, I should say. Gabe will be hosting the webinar next week on May 27th. So please join him if you're able to do so. Have a great rest of your day. Thanks again.